My lord and my lady, I call the matter of President Zuma and still South African people are actively refused NGT KZN and others.
Mr. Sakara, Mr. Masood and I appear for the applicant in this matter.
Yes, thank you.
May it please the court, my ladies and my lord and my ladies, I appear for the state in the criminal matter. As discussed in chambers, my lord, that matter will not be dealt with immediately. During the course of the day, we will determine a holding date for the postponement until after the judgment in this matter. May it please the court.
Thank you.
My lord, my ladies, Ms. Adhikari and I appear for the applicant in the civil case, that's Thales, and the second accused in the criminal matter, Thales.
Yes, thank you.
May it please the court, my learned friends, Mr. Breitenbach, Ms. Mayosi, and Ms. Raja and I appear for the state in the two stay applications.
Yes, thank you. Mrs. Kakan.
Yes, the court, please. The structure has changed somewhat, but
Yes.
I'll try because of the discussion we had,
Yes.
for which I'm grateful. I want to start this matter with a couple of things.
Just hold it for
Yes. So we're just trying to sort ourselves out. Please, very quick. My head's up. We just have to share. We can start, we just have to share because I don't know whether what happened to my head. No, we're looking for the applicant's heads, the first applicant's here.
My lord and ladies, if I find an extra copy, I'll try and
That's
favor the
fine.
court with a copy. My lord and ladies, we have an extra copy.
That's fine. Thank you. Thank you very much.
My lord, if you find my notes on it, you'll forgive me for the insults.
Yeah. Okay.
My lord and ladies, I want to start with a couple of things in this matter, and I will keep to the time that we were instructed to keep to. A couple of things, first because they relate to my colleagues. An argument is raised in the papers about a couple of things, conduct of colleagues, and one is that of Mr. Trengov himself, and I've spoken to him. It's not an argument we want to pursue because there are much more important points about this case than that, and so that point we won't be raising at all. But what we will not apologize for, and we will do quite strongly, is our points about the institution and how we believe the institution has conducted.
Can I just get you correctly, Mr. Sikakan? When you say you don't want to pursue that argument, does it also relate to Mr. Downer?
It doesn't relate to Mr. Downer, and I hope I can persuade Mr. Downer why. It doesn't relate to him, it relates to Mr. Trengov, because quite frankly at the time, we didn't know he was going to be our colleague, and basically it doesn't make any requirements, so it's a point I'm not going to pursue. And I hope even about Mr. Downer, when I deal with the point, he will realize that it's not a personal attack on anyone, it's about the institution. Having done that, I want to sketch what we're going to do in this case. One of the issues that this court is faced with today, with all of these papers and files that we have, is basically two issues. There are two competing main issues about which this side and that side differ. And before we get into the details about the Sanderson case, the Van Heerden case, and all of them, I want to say to this court, this case is about two legal philosophies. That's what it's about. And we're going to persuade the court, we will try, that the legal philosophy this court should adopt in trying this matter, in considering the difficult matters we're going to raise, is the legal philosophy we choose. We're going to present is the one that should guide the country and the courts and the prosecuting authorities. And so the most fundamental issue to consider here is an obvious one. First, because this case is an intersection of law and politics. It's an intersection of law and politics because we're not discussing the lease here today. We are here to argue about the legal foundations of the nature of the state we chose. We're here to discuss and maybe argue about how true we are to the values and principles that we set out in both the interim constitution and now our final constitution. We're going to try and persuade this court, as difficult as it may sound, that in the two legal philosophies, what separates them, let me give one legal philosophy. And it's a philosophy that I think many people, when it relates to Mr. Zuma, adopt. It's old. It was changed in the 12th century by certain people, but they were not committed to it. Up to today, we are not. And it's this philosophy. When we think you have done something heinous and we don't like what you've done, and I'm using the word when we think, because that is the start of an accusation about any human being in this room. You will be suspected of doing something. When we suspect and we think that you've done something we dislike, we will do with you as we please.
Sorry, we being?
Being society.
Okay.
Society. I haven't come to the MP at all and the court. Because it's a philosophy. We will do with you what we like because we believe you've done something we do not like. And it's a philosophy that guided many people for a long time, for centuries ago. And then there's the second philosophy. It's a legal philosophy. Again, in fact, in South Africa, we should remember the first one because it ended with apartheid, at least we thought. When they suspected you were a terrorist, when they suspected you were a danger, when they suspected that you were black but you were not supposed to be in town, it did not matter how they brought you to court. That's the philosophy. And we're here to tell the court we do not subscribe to that philosophy because we thought South Africa left it behind. Here is the next philosophy, and this second one is the one I want to persuade this court because I know that only this court is the supreme custodian of the philosophy I'm about to tell you about. Having seen what happens when people adopt the philosophy I talked about first, in fact, in simple terms, it's called mob justice, the other one. It's done in the jungle. The second one that we left behind in 1994, when we adopted, in 1996, we adopted this constitution. And when we adopted a particular political settlement for which we are praised the world over, what did we take? We decided that we are a constitutional state. We decided that it does not matter what we think of your child who's accused of rape. We decided that we do not care what we think of a suspect. The values that will guide how we deal with human beings, including the ones we don't like, is going to be the values of the Constitution. It's a tall order. It challenges our humanity to want to lynch someone we hate. It challenges us, how true we are to those values that when we suspect someone because we hate, because we dislike, or maybe we find what they are suspected of having done heinous, and unthinkable. The philosophy we adopted, for which we appoint our judges, for which we have these courts, is that it does not matter what a citizen is accused of. Their human dignity and the manner in which those who prosecute them and those who deal with them and those who have power must exercise that authority with due regard and respect to the values of humanity enshrined in our Constitution. I say it's a tall order because it challenges our bias as human beings. It challenges our intentions, our need to lynch someone we dislike. I may not like Mr. Zuma myself. I may not like him. Many classes of people don't like him. The question I have to ask myself is this. I may not like what he's suspected of having done. The question I ask myself every day is, can Mr. Zuma, can your son and mine, accused today of anything, should they be dealt with outside the four corners of the Constitution because they have done or they are suspected of having done what we don't like? The legal philosophy I want to persuade this court about, I don't need to persuade the court about this because it's the philosophy of our courts. You are the last custodians of the Constitution. But I have to persuade my learned friends, the NPA on the other side, because they start their argument with telling this court how serious corruption is. Of course, one wonders why we have to be given a lecture about how serious corruption is. It is. We are not one of those species that don't understand that corruption is serious. We do. In fact, in this room, I can hazard to say with everybody here, and my learned friends on the other side who want to lynch Mr. Zuma to a prison cell, I'm probably the only one in this room who's asked him this question, because I did. Mr. Zuma, are you corrupt? It's the first question I asked him when I met him. Because...
What about Mr. Masugu and Mr. Sikakane?
I know that Mr. Masugu is guilty all the time, so I don't have to ask him. Same with Mr. Trengov. I don't need to ask them. But I'm telling this court it's a tale, but it's a tale Mr. Zuma can attest to. It's my first question I asked to him. Because as a human being, I realized that as we sit in the coffee shops of Rosebank and our white leafy suburbs to talk about Mr. Zuma, to probably seek white validation and impress our friends, we have never for a moment paused. What do we know that he did? Secondly, suppose we know that he did what he did. I was asking him these questions because I wanted to clear my conscience to represent him, because I don't want him to call him corrupt until I know. Suppose we know that he may well have done what we suspect he did. The last question is, does he get stripped of human dignity? Is there a reason to deal with him in a particular way because he is Mr. Zuma? Is Mr. Zuma different from my son who may be accused of sexual assault or rape tonight and I will look for a lawyer to represent him, and yours? Must he be dealt with less humanity? That is the philosophy we want to tell this court. He has had no other place in which to tell this story. Because this place where we are today, I'm happy about, is the only place that the Constitution makes the custodians that can deal with our values in the Constitution without any regard to political whims. And in many cases, my learned friends have quoted, and I'll take you to the Van Heerden, to the Sanderson case, and all of those details, is that all of them as much as this remedy we ask for a prosecution to be stayed, is a very difficult remedy. And it's not a remedy we take lightly. We must not come to court and give the impression that people will commit crimes and they will come to court to tell the courts that they shouldn't be tried. But let me tell you what actually underpins the philosophy that we think the National Prosecuting Authority subscribes to in the manner in which they have dealt with Mr. Zuma. I called it the mob justice. It's driven and inspired by something all of us in this room have, to varying degrees. It's bias. And my lord and ladies, there are two forms of blindness in society. One is physical blindness, people who can't see. And the next one is the most serious blindness that we all suffer from. We just don't realize it. It's caused by bias. A blind man can bump that door, bump a hill, bump a pole, and on occasion may fall and injure their elbows. That's what physically blind people face every day. But they injure no one. The people who are blinded by bias and prejudice, let me tell you what they do. And I'm going to take you painstakingly to the discussions in the so-called spy tapes, because it will blow your mind how people we give power discuss judges, discuss other people, and discuss prosecution. People who are blinded by bias do what we've been doing for the past 15 years. We think you are guilty, we will do with you what we like. That's what they do. Historically, what else do biased, blind people do? People who intellectually and psychologically cannot see. They do not ask the question, what do I know about the person I'm lynching? And that's why what they've done in history, people who are blinded by prejudice, they've discriminated against them because they are black or because they are women, and they've killed them. They've sent them to the gas chambers because they are prejudiced against them. Those who killed Benito Mussolini on the 28th of April 1945 were not happy that he was dead with his mistress when they walked him down the streets of Sicily. What did they do? They killed him. They were not happy. They dragged him down the street. They were not happy he was dead. And they hung him up. And they looked at him. They took a step back and looked at him, and they were not happy. They went back and turned him upside down. And I'm not saying Benito Mussolini was a great man. He was a fascist. But society moved from then, because that's what separates us from those living organisms that live in the jungle. My lord and my ladies, I'm here today to tell you that for the first time, I'm going to try and persuade this court, because it's where I should. But I'm going to try and persuade everyone who's hated this man without thinking once how much they know about him and what our system should do to him. My lord and ladies, we do not take this remedy easily. We've not come here to do what our learned friends and people in the media call it. I don't even know what it means. They say we are adopting a Stalingrad approach. We are here to delay because that's what Zuma does. That's what Zuma does. You know, he goes to court as if he shouldn't. All of us in this room will go to court the day we're accused, and we should. We are told he adopts this all the time. I'm promising you this. I'm going to read you in the spy tapes a discussion between a prosecutor and an outsider seeking to trap Mr. Zuma so that they know he'll go to court, so that the thing could be delayed. I'm going to tell you in the spy tapes, I'm going to read them verbatim, of people calling our judges fucking Indians, calling a judge, Ponen, that Indian guy, referring to Judge Ponen, to Judge Falam and others in the most derogatory terms. because they believe they can do anything to a person they suspect. My lord and ladies, I want to say the cases we've quoted to you, most of them, the permanent stay was not granted. Because it's important to know that those who commit crimes must not easily assume that courts will forgive them simply because there had been 2 delays, 3 delays, or even 4. But of course, what our learned friends have done in the 38 cases that more or less they've quoted, 5 of which are about the permanent stay. We quote to you the Sanderson case. We quote to you the Van Heerden case. We quote to you the Bothma case. In fact, the Sanderson case and the Bothma case are important because they're talking about someone or people who had committed what we all in this room hate, sexual assault on little children. We quote them. We quote them because the courts, like this one, refused a permanent stay. But we also quote to you what our learned friends don't quote. We quote to you the case of Phillips and others, where it was granted because the delay was unreasonable and was 3 years. In this case, as I will persuade you when I start with the details of this case and the story, we are talking about close to 2 decades. And as I start this story, we will structure this way. First, because it's a story that hasn't been told, and I will try to summarize it. It's what actually happened about this man we so hate. What happened? How did it start? And I'm going to persuade you when that story ends that it starts like it finishes like it started. It starts with Mr. McCarthy investigating him, and it ends with Mr. McCarthy talking to presidents, to ministers, colluding with outsiders for nefarious political purposes to prosecute a citizen. That's what it is. Secondly, as I said, I will tell that story because I want us to forget for a while that we're talking about Mr. Zuma. I want us to remember for a while that we're talking about a son, a relative, someone who's accused tonight. My Lord, I have graciously, and my learned friends said this, there's a quote I start with. I think it's important that I do this about Mr. McCarthy. Although he has not disputed this, I think we have a duty that because we did not attach that letter and we ourselves, quite frankly, have not been able to locate that letter, I want you to disregard that quote because we have a duty to find it if we're going to rely on it. So I've told my learned friends that as a lawyer, I cannot rely on that paragraph until I had hoped that the letter would be found, but I don't think it's proper to argue it. Now, the next point we're going to raise, as I said, the structure is that we will tell you this story. The second part of our argument is that we will tell you what is common cause in this story. Something we, as much as we hold different legal philosophies with our learned friends, things that we all agree did happen, and challenge this court to judge for itself whether it should happen that way. And thirdly, I will then set out briefly the principles that our courts, both in this country and elsewhere, in other jurisdictions, have set out for us that should guide that we treat this remedy with due circumspection because it's a serious remedy. But towards the end, Mr. Masugu will then set out for this court something that I think we also don't differ about, is having set out what has happened and how the prosecution team, in our view, may have conducted itself in a manner that was, it would be an understatement to say, a little overzealous, truly without due regard to the fact that a citizen must be prosecuted, yes, but must be prosecuted within the confines of the law, the NPA Act, the prosecution policy, and the Constitution. And we're going to rely, as I said, the principle about all these cases, whether it's about delay, which we complain about, and it's common cause that there was delay, we differ about who was responsible. Whether it's about the fact that there has been prejudice, trial prejudice as a result of that delay, but most importantly, one of the key questions in all of these cases, that those that have granted the permanent stay and those that haven't, that the courts have grappled with, is, and this is to avoid people coming to court to say, I don't want to be prosecuted, you've delayed. It's whether really there is anything exceptional, extraordinary in how the matter has been conducted. And lastly, whether Section 35(3), it used to be Section 25, as we'll see in the other cases that relate to the interim constitution, has been compromised or violated to a point where we could say there has been a fair trial can never happen. My Lord and ladies, Mr. Zuma's prosecution dates back, and not the investigation, it dates back to that decision of the 23rd of August, 2003. And if you really want to focus it on that aspect. And we argue that from that day, it starts to limp because different things are done. In fact, Mr. Downer reads the things we say about him, and I think the descriptions may not be fair, is that I want to show this quote, that Mr. Downer, in this matter, of all the prosecutors that dealt with this matter, whether you differ with his motive or you don't like what he ultimately does, trace Mr. Downer from the 23rd of August 2003 to now. He's the only prosecutor that has been consistent about what must be done to an accused.
Just on that point, from 2003, I think I read somewhere that Mr. McCarthy, didn't he join the NPA in 2005?
Is that?
Mr. McCarthy.
No, Mr. McCarthy joined much earlier. He started the investigation.
Is it?
But I'm talking about Mr. Downer.
No, I understand. I'm just taking the two.
And I'll take you through that, because when we say we attack this constitution, we're not attacking individuals. There have been people who consistently, when wrong decisions were made, and I will refer you to those, said, we find this indefensible inside the NPA. And they've been consistent about that. So, what actions happened? What did Mr. Zuma go through, and what did he do?
Let me just try and understand you here, Mr. Stakhan. You said the 23rd of August 2003 was the start of Mr. Zuma's prosecution.
It's that decision. It's not.
Is that decision?
It's the decision that is the genesis of what happened later. Before that, it was investigation.
It was investigation.
About which we're going to tell you something.
Yes. And then the decision was that he was not going to be charged with Mrs. Shea.
That's one of
Yes.
the issues we raise.
That's
We raised that day, particularly, although before I start with day 1 to day 365, is that is the day when Mr. Nguga stood out and told the public what has influenced most of us until now. In fact, when I asked Mr. Zuma whether he was corrupt, I was probably influenced by what Mr. Nguga did, because he told us this: I have a prima facie case against Mr. Zuma, but I will not prosecute him. So that date is important for that reason to us. It starts what we think.
If we look at that decision, and you can assume in our favor, we've read the papers before us from cover to cover. At that time, if we look at how prosecutorial discretion has to be exercised, because this is about prosecutorial discretion, is the focus only on whether one has a prima facie case against someone, or is it also whether one will have successful prosecution against someone?
Well, I'm going to quote a case, my lady. It's an important question because it's one of the questions about which we differ in how we approach this matter. When does a prosecutor decide to prosecute? They will tell you, if they are honest, we're not dealing with Mr. Zuma, that in fact Mr. Downer says this in his memorandum. You have a prima facie case against someone, that's the time to prosecute. What we will see that Mr. Nguga wanted, because I will read what he wanted in his letter, and we've raised it. He wanted a guarantee that a conviction would happen. Now, my lady, that is not the standard. We say. We will quote to you cases that deal with how a prosecutor should deal with a matter. In actual fact, prosecutors are governed, all of them, they know it better than I do. I'm no expert in prosecution. Is that they assist these courts to evaluate evidence, and they do that without fear or favor. And one of the principles that must govern them, as Mr. Masugu will tell you, is that they should not work overzealously to get someone convicted. That is not their task. And we will tell you that from that day, the decision by Mr. Nguga, we call it the day he decided to hang Mr. Zuma out to dry. And isn't he dry? He told us to suspect the things we think we know about him, but I won't do anything. So that was the decision we're talking about. But it starts this way. Let me go back to exactly day 1. As the case says, the NDPP case versus Zuma, that's the one of the SCA that we've quoted in our heads. This matter has had a troubled history. The SCA, with all these other things they say about Mr. Zuma, and my learned friends quote them, they do acknowledge that. So the source of the genesis of this, or the genesis of this case, is the arms deal. It's the arms deal. That's the beginning. We are going to investigate as the country, so the investigators are going to investigate the arms deal, because there were allegations. I think we can all remember Mrs. Patricia DeLille. I cannot speak like she did, but she alerted us to what she called allegations in Parliament of how the arms deal had been conducted. That's how it starts. Where is Mr. Zuma at the time? He's an MEC in KZN. But this is a cabinet decision. Now, of course, we call that because I will call the judges, my lord and ladies, to look at you don't have to look at it now, but it's page 3,399 of our papers. Because you will see therein that there are references in the indictment to the arms deal. So there is no dispute about how it started. In fact, the answering affidavit itself of the NPA acknowledges this was the catalyst. I think it's paragraph 95 of it. But anyway, during 2000, as we say in our heads, what we used to know as the Scorpions then was established and located at the NPA. The head of the DSO, that's why I said to you, it ends as it starts. Mr. McCarthy, the one I've said calls judges Indian this and other people F this, when he's speaking to politicians, taking instructions about how to do his job. He becomes the head. And who else leads this place where he is going to function from? It's Mr. Nguga. This is very interesting because I will take you to what Mr. Nguga himself says about what we will see in the spy tapes as I read them. When he had long left the NPA, he was telling them when to prosecute and how to adjust it to the man he seems to have been his disciple of, Mr. Thabo Mbeki, at the time. He is a self-confessed political ally of Thabo Mbeki. He admits it himself. You just have to read at page 4,415. That's where he admits it. While I'm there, I want to tell this court that we're going to harp on that interference that started by that happens later, because Mr. Nguga answers it for this court. He answers it when we say, what the hell is an outsider doing, telling prosecutors, no, wait for Polokwane a bit, this fool called Zuma, let's wait and see how we're going to deal with it, maybe do it closer to the time, telling prosecutors the timing. How does he tell this court? He has told you, my lord and lady, why he did that. He doesn't tell us which section of the law allowed him to. No, he tells us, oh no, I was married to a deputy president. That is his words. I was married to a deputy president, therefore I had an interest. Please, it can't be. So, anyway, one of the first tasks of the Scorpions, the DSO led by Mr. McCarthy, was to investigate the allegations of fraud and corruption in the arms deal procurement process, wherein Mr. Zuma was mentioned. And of course, one could have no difficulty with this because we agree corruption is a serious matter that had to be investigated, wherever it happened.
Mr. Sikhapan, I just want to flow with you. He was not mentioned at that stage in 2000.
No, he was not mentioned in the investigation.
You just said, because that's what you said, that he
was...
Yes.
He was... I'm saying the procurement process mentions him, but he's not mentioned in the investigation. He's not told that he's being investigated.
That actually came out on the 26th of September from the affidavit of Mr. Sheikh.
Yes.
Yes.
That's how it came up.
Yes.
We will tell you how it also comes out, because he asks at some point, am I being investigated? On 6 November 2000, Mr. McCarthy started this investigation in terms of Section 2813 of the National Prosecuting Act. I will keep calling it NPA Act. I hope that will be in order. And one of the main targets of the investigation was Thomson CSF companies, which was part of the consortium which had been awarded the contract to provide corvettes to the defense force. But I'm not going to come to explain what the different processes of procurements are. I don't want to scare people here about types of arms that we needed, because it's not important. What's important is that it had to deal with how the South African state procured its arms. That's how it starts. And of course, as it would later turn out, Mr. Sheikh had an interest in Thompson CSF through the company called Ngobi Investment. But we say that it's in volume 10 at page 2730. The answering affidavit does not dispute it. You can also see this in Annexure A4, NPA 4 at page 3097. Now, of course, this company, Thompson CSF, the auditors, I think at the time, and if I'm mistaken, nothing turns on it. It was Arthur Anderson.
Yes, it was Arthur Anderson.
That they had become aware that Zuma was involved in bribery.
Sorry, I don't want to interrupt you, but I just want to follow it properly.
Yes.
Because you said Thompson was targeted, but the reason, as I understand the papers, he was targeted is because Chippy Sheikh had been a member or played a part in the defense force, and that's how it's linked.
That's
so I
the
want
link.
us to come with it.
Absolutely, that's the link. When I say targeted, I mean, maybe I should use the word...
No, I don't mind using the word targeted, but there was a reason why it was targeted. I don't want us to leave it there.
Absolutely.
There was a reason, because they were looking in all the companies, and then they discovered Sheikh, and then they were linking the Sheikhs.
And of course,
in other words, the investigation was directing them towards Thompson.
Yes.
I think let's put it that way.
Absolutely.
Yes.
I'm happy. I'm indebted to your leadership. Now, of course, the DSO then, the Scorpions, on the 24th of August 2001, did take the decision to investigate the matter, focusing on those companies, Thompson Holding, Alan Tetar, Mr. Sheikh, and Mr. Zuma. It's common cause that they did. It's common cause that they did. And the answering affidavit confirms it, does not dispute it. Page 2732 of the bundle. It's paragraph 116 of the answering affidavit. Now, from the government side, the focus of this investigation was not one of the decision makers, we argue, in the arms deal, but Zuma. We say this because it becomes clearer as they investigate. By the way, Shabir Sheikh, as we said, was a close comrade of Mr. Zuma, a close friend, a financial advisor. And I'm not using those terms of close comrade because we should loosely. I'm using it because it's at the center of the relationship between them. It's a relationship most of us may not understand because we were not comrades, but that's how they call each other.
Just as a matter of interest, Mr. Kane, because Mr. Tetat is going to feature prominently in this proceeding. Where is Mr. Tetat?
As far as we know, we've said this, Mr. Tetat is...
Because the papers say...
Deceased.
Is deceased, and they're saying he's in France, he doesn't want to come to South Africa, the second applicant.
Thales says he does not want to come to South Africa. He doesn't want to come. So the impression created is that he's not
we have not repeated this in the supplementary affidavit, but we at the time we were informed that he's is either deceased or indisposed.
No, there is no indication that he is deceased according to Thales.
Yes.
Yes. Thales seem to indicate that he doesn't want to come to South Africa because he is probably going to be arrested and charged.
So in our case,
Yes.
the affidavits made clear that the 4 potential witnesses are all unavailable. And in particular, Mr. Tetard had provided an affidavit as long ago as 2004, where indicated he would not come back to South Africa.
Yes, but that's what
number
it's-
one.
yeah, yes.
Number two, we have
You
no
mean the
idea.
affidavit of when?
2004.
So
That's the
we-
affidavit which the
Yes,
state
we want
say-
to know where is he now?
2009 as well.
Yes, where is he now? As we
the
speak,
question of the
because he
indisposed
features
person is
prominent.
Mr. Moyno,
Yeah.
who is, we understand in Pretoria, is not in a position, as the affidavit suggests, in a position to give us any instructions.
But
one
it
way or
is
the
not
other.
your case that he's deceased.
There's none of the witnesses, none of the 4 witnesses
Because
on the
there's a
evidence.
conflict
We don't
there.
know.
Yes.
They may be deceased. We're not in a position.
But that is just a maybe, Mr. Katz, because what really concerned us in reading of the papers is that in the papers of the first accused, it was said that Mr. Tetard is dead. And for that matter, we saw the conflict in the papers filed by Thales about the unavailability of the witnesses. And that's the level that Thales had placed it.
I have to make a confession. I haven't read those papers. I mean,
No, thank
we've seen the correspondence of the strikeout application, etc. But in our case, we have no knowledge that any of our potential witnesses are dead.
As far as you know, they are still alive, but they're not prepared to come to South
As it
Africa.
is.
That's your case. Thank you. Thank you. Sorry, Mr.
I think, look, I don't think Mr. Katz has helped us with that
no,
question
yes, yes,
because it doesn't resolve the question.
We were trying to reconcile the conflict.
We allege that he is deceased, but I will be the first to tell this court if we get different information, even this week, because as far as we know, he is deceased. But the court has to know if there is doubt about it, and no one has told us. And we will tell the court the truth about that if we are wrong, that he is deceased.
Yes, thank you.
Now, as I said, the focus was the decision makers. But one of the things that later emerged, and of course, this is, in my view, common cause, is that one of the letters that linked Mr. Zuma, one of the letters that linked him remotely to this at the time, was a letter written to Mr. Gavin Woods, who was the chairperson of SCOPA at the time. As far as we know, it is common cause now, and we've stated it in our founding affidavit, it's not contradicted, that it's common cause that that letter was actually written by Mr. Thabo Mbeki. Nothing much turns on the letter, but we're trying to tell the court that the link with Mr. Zuma and the arms deal, the submission we make right at the beginning, is shaky. Not shake, shaky. The state concedes, as we know now, that as early as the late 2001, Thompson, Sheikh, and Zuma were in essence suspects together. And that's paragraph 125 of the state's answer. They don't dispute that. The investigation was directed at all of them together, and not as separate units. This much, too, is common cause in these papers. I mention this because it's going to become clearer that Mr. Zuma was written as Mr. X in the investigation in order to conceal it from being known that he was part of it. He's the only one who was not mentioned by an institution that seeks to treat each and every citizen equally. And the answer, which I find patronizing, is that we're doing it for his favor. Don't want to mention a deputy president. It was done for his favor. They were doing him a favor by hiding from him, even from him, not just the public, that we are investigating you, but we will tell others. This, according to the NPA documents themselves, was unusual, because basically it pointed to a clandestine way of dealing with one of the suspects and not the other. And we say...
Can you just, sorry, Mrs. Kakan, let me just understand you on that point. Are you saying that the fact that his identity was hidden,
Yes.
that was done in bad faith? Is that
Yes.
what you're suggesting?
Yes, and I invite this court, I'm going to invite this court with the details that I will read. Because a lie is told later that his counsel, Mr. Casey Knight, was met. He was never his counsel. And Mr. Nguga knew that. He had been dealing with his lawyers. Well, for us it raises a red flag. It's one of what we call, before the 23rd of August, just a red flag of how are we dealing with this investigation. It raises a red flag about the bona fides of the NPA. And we say it was the start of the clandestine operations and irregular conduct in how this was investigated. Later, to bolster this point, I'm going to take you to what has become known as the Browse Mole report, which was unlawful, irregular, intelligence, rogue intelligence operation done in order to nail Mr. Zuma, unlawfully.
Sorry, Mr. Sekatane, I don't want to interrupt you unnecessarily. I know you're going to come back to this point. But is it the submission that the Browse Mole report had any evidentiary value in the case that you're applying for the stay of the prosecution?
Absolutely. Absolutely. It's important, and let me raise this point, my lady, because it's important you raise it now. Because the point we make, we've not been given all of the documents that we've asked for. And it looks like a petty point. But I promise this court that if we find some of the documents this week, classified or not classified, if we find them that we've not been given, we are going to make a request to the NPA to give them to us. We will list them. And so, the Browse Mole report is at the center of the unlawfulness of how this was conducted, how an outsider, former journalist or a journalist, I don't know what his job was, because it's difficult to know when a journalist is an intelligence officer and vice versa. But he is brought in to do a clandestine investigation. And quite correctly, my lord and my ladies, this becomes something, I think one of the prosecutors in this regard who I think was acting properly, it becomes Mr. Pikoli's concern later, but we will deal with that.
You mean the issue of the certificate?
Of the Browse Mole report.
The certificate, because there wasn't any certificate provided authorizing this.
Yes,
the investigation.
Absolutely.
Yes.
And how it was done. It's how it was done. Now, during October 2001, the NPA made various warrant applications for search and seizure and executed them against Sheikh, Kobe companies, and tint companies' offices. We find this, as I said, in Bundle 1, Volume 30, we stated there, and it's not disputed. If you check Volume 10, the answering affidavit, it's at page 2941, paragraph 578. There is no issue there. These warrants at the time excluded Zuma. It was not mentioned. It's not there. The prosecution team has recommended that Zuma residences and offices be searched. Now, I think it's important to state that despite this advice, I would ask my juniors to give me a copy of this because it would be important to read later, is that the advice given to Nguga and McCarthy was that they should. That's why I said at the beginning, the rogues that run this ignore advice from upright prosecutors who just want to do their job. It was rejected. I will deal with what the answering affidavit does with this, because I think had I been Mr. Downer in this matter and I'm asked to, for people I've advised all these years to do the right thing, I would have drafted a two-liner which says, I'm Mr. Downer and I told you so, because he told them so.
So you regard him as one of the upright prosecutors? Upright, Mr. Downer, because he's been consistent.
Well, in that
years.
aspect, he's been
Yes.
consistent.
Yes.
Absolutely, advising
So
them.
you use the phrase upright prosecutors.
Well,
I just want to, you know.
I use it because I would never attack Mr. Downer as a person. I take issue with how the difficult position he is placed in being a deponent in this
Yes.
matter, because he now has to depose to an affidavit that defends an organization that rejected some of his advice. I really do sympathize with the position, the invidious position he finds himself in. We make reference again to a memorandum of April 2002 by Advocate Lynette David, who submitted it in regard to the bribery allegations against Mr. Zuma. Of course, the purpose of that memorandum was to advise on the evidence which had emerged against Mr. Zuma. We take no issue with that because the prosecutors, they had to do that. Davids considered the evidence which the DSO and NPA had and concluded that there was insufficient admissible evidence against Mr. Zuma. That we find in volume 7, page 1787. And it's also annexure JZS16. May I read what she says to them? Davis. Just bear with me. My juniors use computers, I use paper.
You don't want to reveal your age by that.
I think my forehead reveals my age. But I'm going to go to read this. I'm not reading it for any theatrics. I'm just reading it because it is advice given to them. JZS16.
You said page?
It's page 1788. It's the supplementary affidavit where we deal with it. JZS16.
It's 1954.
Oh, 1954. I'm sorry. It's 1954. Before that, in fact, while you're there, the one before that is the one by Mr. Downer that I referred to, but I don't want to bore the court with reading that. But there, she deals with all of these cases, but I want to take you to the last, her conclusions. Can I take you to paragraph 5 to 7 of this? Because he warns about what faces the investigation. She says, the biggest challenge facing the investigating team is how to convert the information obtained from the letters, etc., into admissible evidence. In the absence of this kind of outstanding evidence, as indicated in this schedule, it's the schedule she attaches. I would like to read it, but it's attached to that. Of this kind of indicated in the schedule, the facts that can be proved at this stage of the investigation are limited. So they know very early skating on thin ice. It says it is common cause that the tetrad letter, it's going to become important later, this tetrad letter.
Sorry, Mr. Sikagane, the third letter meaning the fact.
Yes.
But isn't that indeed, if we have to also juxtapose then what the view was of Ms. Davids then, and we have to consider the historical events that happened after that, and whether her view was correct.
I think it's important.
Because if I understood the judgment of Squires J correctly, then clearly that was found to be admissible.
I am not asking you
Yes.
to disregard whatever you may want to regard. All I'm telling you at this point
Yes.
is that at that time, they were being advised on how to approach the investigation, and they ignored it. You may well say that she was wrong, and I'm not suggesting, I'm not analyzing her advice,
Yeah.
nor am I analyzing any other advice they were given. The point I'm making is this. Because I'm trying to to demonstrate the overzealousness with which this was being pursued against advice from the most senior prosecutors.
Let me understand the overzeal. Mr. Downer's recommendation then was to prosecute,
Yes.
but Ms. Davids was to say don't prosecute.
Was wrong.
But then there was a conflict
Yes.
at the time,
Yes.
and then it seems Mr. Nguga thought that he would take
Well,
Ms. Davids' advice. No. I'm just testing the overzealousness
conflicting-
because is it not lawyers talking? Because we don't agree.
Well-
One says this, one says this. There has to be a middle line.
I actually do agree with both of them, as differing as they are, because we all lawyers, we differ. But I'm going to say to this court, follow the trend of what Mr. Nguga does throughout this matter in order to judge what I call and what we submit are his mala fide actions at the time. I do not take issue with the fact that they would get differing views at different times. But even with that, Mr. Nguga has to act, to use that discretion properly and demonstrate the decisions he's taking and why he's taking them. That's what I want the court to look into, is why does he take the decisions he takes? And of course, I want the court, as difficult as it is, to look at what I call the pattern of behavior in this matter in order to analyze. When I say some of the prosecutors acted properly, I'm not saying I agree with their advice. I am saying, as lawyers, as we all do, they gave at the time what makes sense to me or makes sense to another lawyer, but it was based on law. It was not based on a political consideration, a discussion with a minister, a discussion with somebody else who is outside the institutions. When Mr. Downer and Ms. Davis advise, they are lawyers, they are analyzing what's in front of them. What we know now is that Mr. Nguga's decisions were political decisions.
At that stage, though,
Well, at that stage we
there was
didn't know.
Davids. No, but also there was Davids
Yes.
who seems
Who
to
says there isn't
yes,
enough evidence.
Yes.
I agree with you. That's what it is. And I think at the time he had all of that advice available. But let me take you to the next bit we argue. Because it leads to this. One of the points we make in this, and my learned friends use section 155 and 156 to say they could do it, it's a discretion. We differ about that, but in any event, let's analyze Nguga's decision at the time. He doesn't charge Mr. Zuma together with Mr. Sheikh, because that's an important event to analyze why it happened. and how it happened. Our learned friends say he was just exercising his discretion, even if he ignored the advice. That's what he was doing. But anyway, we argue that at that point that we're talking about, Mr. Zuma and Mr. Sheikh, with prosecutors applying the law and the principle that should guide them to start a prosecution, should have. And when they didn't take that decision, I want this court, when we talk about the inordinate delay, and my lord and my ladies, there's a misunderstanding that when we say it has lasted 15 years, somehow we're suggesting that there had been no time when Mr. Zuma went to court. No, he did. And there may be times actually that the NPA could do nothing about it. But from that day, they could have charged. They could have charged Mr. Zuma, but they didn't. We want you to consider what we say is the first time that causes a delay because he could have been charged. And Mr. Zuma is not responsible.
But I think you're ignoring the evidence that at some point, Mungas assembled, 8 of his deputies,
yes,
to ventilate the issue with them. And out of that meeting, they seemed to take the view that was taken by Davis. And he thereafter ran the decision with a private senior counsel.
Yes.
How then can you say the decision was politically motivated?
Because I will demonstrate later that at the time when he had advised to do so, because he knew then that once you have, and then when I say Mr. Nguga, maybe we can, the institution,
Yes.
the NPA, maybe I should
Fine.
use,
Just,
Yeah.
Maybe it's better to refer to
I'm saying
Nguga's
at the
decision.
time, given the principle on the basis on which you should prosecute, on the basis of which they prosecuted Sheikh, who allegedly, and I use this, was a partner in the alleged crime. In fact, it's later we find out that it's actually the same issues that they would like to canvass with him, to charge him for. It's the same issues they say later. Mr. Zuma's case has become stronger because of what the SCA eventually said. So we submit respectfully, my lord and ladies, that from that point, if you look at delay, they could have charged him. They could have charged him. In fact, they should have charged him together when they decided to charge Mr. Sheikh. And maybe for someone...
But as I said to you earlier on,
Yes.
he was faced with these two conflicting decisions.
Yes.
He ran the decision with 8 of his deputies,
Yes.
who seemed to agree with Davis.
Yes.
And he was not, it would seem, not satisfied with that.
Yes.
He then went out of the institution to canvass the view or the decision with an independent private counsel.
Yes.
And
He went to Mr.
Counsel
Moran,
yes, and he seemed to have agreed with Davis.
Yes.
So that's where I really have a problem.
I'm gonna come
How
back
then
to
can
that
you
issue
say
because-
the decision was politically motivated?
Lord,
Because he took all the safeguards.
All right. My lord, can I ask the court to bear with me with this
Yes.
story? Because this is exactly the problem with how the Mr. Zuma's story
Yes.
has been done. We compartmentalize it, and we refuse to see the pattern of behavior. I'm not saying that to the court,
Yes.
but I'm inviting the court, and I will come back to the issue, is that I would not call a decision mala fide easily. I am
No.
saying there's a pattern I'm going to read that points to an inference that I want this court to make, that at that time, and we use the word, when they decided we will try Mr. Sheikh, and let's hold on with this one. We say it's because as as the NPA said, they want a guarantee that there will be a conviction, not anything. And which is not the standard. And we say a lot has happened in that trial of Mr. Sheikh. Now, ordinarily, people can think, well, I will charge you later. We will charge your partner in crime at a different time. It's not that. We're going to take you through what we think are prejudices that an accused who was not charged with someone he could have cross-examined, and they are alleged to have committed a crime or an offense together, what that accused faces when that matter has been allowed to run in order to see how far we can go. It's the same evidence, but let's try this one alone so that the big fish we want, we are certain. That is the pattern I am going to raise, is the issue. The court can differ with me on that aspect, but I am suggesting that at the end, the pattern of behavior and the discussions about how to nail this fool that we see in the speeches is an issue that I would invite the court to analyze together. And then on the 25th...
Can you take a short adjournment, Sister, for tea?
I don't want to
then
interrupt you unnecessarily.
Convenient time for the tea.
tea. I will come back at 25 to.
Yes, thank
Because the
you.
court...
That's it. Yes.
My little friends and I have looked at the court diary, and the recess ends just before the 7th of October. So the 7th of October 2019 is the first date of the new term.
2nd of October.
The 7th of 7th of October. So we, with my learned friends and I, we're thinking of the next week, my lord.
Yes.
The next week, which is in fact starting on the 15th, and starting on the 14th. And so the 15th, yes. The Tuesday, the 15th suits the parties the best as a holding date for the criminal trial, which will be after the judgment in this court, and we'll plan we shall plan the proceedings according to the judgment after that and the parties' attitudes. And my learned friend for the accused, Thales, Thales has just asked me to put it on record once again that Mrs. Gurrier will not be here and not be necessary to the first year on that date. And the state has agreed. So all in short, the 15th of October is a holding date for the criminal trial after the judgment in this court in these preliminary proceedings.
Are you happy with those amendments? Mr. Zuma, please, your matter.
Yes, I confirm that.
Sorry. Mr. Zuma, your matter will then be adjourned, the criminal matter will be adjourned to the 15th of October 2019. You are to remain on warning until then.
As it pleases the court, my lord and lady.
You can step up.
Yes. You can come and sit here.
Can I just say this because
Yes.
it's in the interest of time, and we spoke about how much time we had when we planned this matter. We did think we had longer time, but can I say that I think the part of the history
Yes.
in the heads of arguments is uncontentious, right? Most of the history. When I say uncontentious, I mean it's things that happened, and therefore we differ about how we interpret them, and largely we differ as my lady Stein was asking about it, that why is this mala fide? Why is it? It's that we differ about. So what I'm going to do, so that because I didn't know until today, I had less time.
No, if we need more time.
Yeah,
please.
I will.
Yeah.
But I know my learned
You want
friend,
the issues
no
to
lawyer wants to listen to another lawyer for a long time. I will try.
But it's up to you.
I will
It's up
try
to
and
you. If you need to
truncate.
clarify something, please do so.
Absolutely, and I will answer those questions that probably are contentious. But can I just go back slightly to the debate that we were having with my lady about, and my lord about that decision? Maybe it gets resolved, because the point I was making is, when we complain about who is responsible for delay, sometimes it gets confused about which times and who started what and who did what. Now, the fact of court got lost here, because the point I'm making for now, I'm not analyzing the decisions, although I've had to, is that we say from that decision, the matter could have started. And after that, we submit that we attribute that delay to not charging him with Mr. Sheikh. And I will get back. In fact, one of the other ways of resolving this question, so that I don't leave it in case I forget where you are, let's ask ourselves, what does the NPA say now in front of this court about that decision? And I'm going to take you to their answer in the answering affidavit, because maybe it resolves it, but it doesn't resolve the question of mala fide, but it resolves what we are saying about it. It's page 2693. This is bundle 10, or volume 10.
Sorry, Mr. Speaker, can I have the page number?
2693. And I'm just going to read that paragraph. Well, I'll read the second one because, to be fair to the deponent, he explains further. It says,
Yes, thank you.
thanks. This is Mr. Downer, who deposes, and we must assume this is what the NPA says, because he does so not in his personal capacity. Says, although I disagreed with Nuga's decision, as I still do, means there is no dispute that it was as wrong as he said it was. And we must accept that this is what the NPA is telling us. But this is where we part ways, and it's what resolves it doesn't resolve it, it makes it worse, maybe. He says the presently relevant point is that it was taken in good faith and not for any ulterior purpose. Now, the NPA does not disagree with us here that it was a wrong decision. Where they differ with us, and they must, maybe, is that they say we interpret that decision as we say it was mala fide. That's all. And I wanted to say, well, to the point I am making now, at least for now, until I read what makes me say the decisions were mala fide, the point is not disputed that it was a wrong decision by the NPA itself. My Lord and my ladies, you will see then that in our heads of argument, we deal with that part of the investigation where we say Mr. Zuma's name first was concealed, and he requested that he be told whether he was being investigated or not. And Mr. Ngcuka answered him. And the answer we have stated it there, that he said that they do not, he refused, basically. He refused to confirm to him whether or not he was being investigated. And so that part of our heads of argument deals with this point so that I truncate it and we move, unless my Lord and my ladies have a question.
No.
Is that the investigation was done in a manner that was clandestine, and there was no legal basis for that. The second point we make is that the decision not to charge him with shake on the 23rd is the time at which we start saying, but we would be long past this matter had that wrong decision not been taken, even if it was bona fide, which we dispute. And so if you go to our heads of argument, you will also see that this is where I would invite the court to read, because it's going to take too long to talk about the interaction with the public protector by Mr. Ngcuka and Mr. Maduna. We have said in our heads, and I submit here, that there was absolutely no legal basis for the involvement of a politician, Mr. Maduna, in the decisions about prosecution. Whatever they are, he had no business in them. And we set out that, in our view, that was wrong. But at page 19 of our heads, you will see we deal with the fact that after that decision by Mr. Ngcuka, Mr. Zuma lodged a formal complaint with the public protector, complaining about some of the things I've just raised. And they are listed therein as follows. It's the manner in which the NPA and Ngcuka conducted the investigation. So he takes it to an organ of state that he thinks is a Chapter 9 institution designed to protect citizens. The second one, he says, the conclusion and the manner in which it was communicated. It's that clandestine way, and not being told, and sometimes being told that it was in your interest that we didn't say it. And he says the continuation after the decision that he would not be prosecuted. He complains about that. And then he complains about what, yes, it doesn't seem until we get to Mr. Ngcuka's precise action and discussions, what he saw. as the abuse of power by the head of the NPA. And as I said, we state there that we don't think the court should not take judicial notice of the involvement, close involvement of a politician with a prosecutor in a matter, about how it should happen and when it should happen. I'm not suggesting that politicians and heads of NPA don't talk. I'm sure they do. But I'm saying there is no legal basis for a discussion about prosecutions and how they should happen. So that area up to where we finish about the investigation ends around page 20 of our heads. But of course, we know that Mr. Nguga resigned just before the commencement of the trial of Mr. Shabir Sheikh, right? In August 2004, I think 31 August 2004. And we say this with respect because this is where we are now, that he did leave behind him a trail of prosecutorial destruction. And what I submit to this court is the gravest prejudice to an accused citizen. As if this was not enough, whatever he had done, as we will see, is that he was continued from his grave. He continues from the grave when he is no longer the NDPP to discuss with them, not just how's it, bro, what's happening? No. When are you doing this? Don't do it this, and McCarthy does the same. I'm going to make a point at the end that conduct of prosecutors should not be tolerated across the board. We should not limit it to prosecutors we dislike because of their race or class. We should do this to any prosecutor who does this. Then on the 11th of October, we all know the Sheikh trial commenced. But one point I need to make there, because we don't have time to get into the details of this case because of the Sheikh case, because it may not be relevant for present purposes, is that indeed the evidence which implicated, and I say advisedly, prejudice Zuma was led. Now you could ask a question. What's the point? I mean, yes, it happened. It was a trial before that, but his own will come and he'll defend himself. But if you know how a trial would have been run, is that these would be co-accused, as we say they should have been. Mr. Zuma was denied the opportunity to challenge evidence that prejudiced and implicated him. There's an answer we get given when we say this. It's, oh, but he was present. He was there. His lawyers were present, although not a party. They were present when Mr. Sheikh's trial happened. We submit that, with respect, that is nowhere near the rights of a person who is a co-accused and can cross-examine and deal with the evidence that may later prejudice him. And of course, it's not just that it will later prejudice him. It's the fact that if you ask now, what would happen if Mr. Zuma, if his trial started or when it starts? Would he call Mr. Sheikh? Is Mr. Sheikh, with what has happened in his trial, as available as a witness as he was had they been together? with no decision made and no judicial comments about one of them, we say, had they been charged together, what the NPA calls what it calls now incontrovertible evidence of Mr. Sheikh, that emerged, and what the SCA has also referred to that way, with his presence and cross-examining a co-accused, the possibility is there that what we call incontrovertible would not be called that today.
Can I ask you on this score, if I understood the argument correct, then it is submitted to us first and foremost that they ought to have been charged together. Again, I've earlier alluded to the fact, is that truly what has been said by Section 155 and 156 of the Criminal Procedure Act? But further to that is that even if two people are charged together, each accused has the right to make the decision for him or herself whether they want to testify. And it is almost assuming that Mr. Sheikh would have testified, and ergo I have a right to cross-examine him. But he had the right to remain silent. He had the right to exercise. So that right to cross-examine the other person was dependent on the other person exercising his right in terms of the Constitution.
I can only say that I can't fault you on that one, but we're on the realm of speculation, right there.
But it's a procedural point.
It is a procedural point, but
Yes.
the point I'm making is that when you have evidence that you say you could charge two people together, in a matter of this nature, and we will take it to a case because sometimes there are cases where participants in an offense can be tried separately because this one killed that one and this one killed that one. This is a charge that says these people acted together. There is the person allegedly who bribed is charged with the person he was bribing. We say when you decide that decision, even we will discuss Section 155 and 156, that decision not to charge them together is not protected by those two sections which deal with how to separate those trials of different accused. We submit that Mr. Zuma's absence in the Sheikh trial amounted to trying him in his absence. And we know that that discussion was happening, that it would guarantee, we will see when it finishes, when Sheikh trial finishes. And we are saying, and as I said this at the beginning, I am not in this court to tell anyone, and it's not relevant, that Mr. Zuma is or is not guilty. And on trial today did an organ of state that can limit our liberties in this room equally. It has the power. My lady, you could be in jail tomorrow if they like. And it's serious power. Can an organ of state with that power against citizens act in a manner that suggests to citizens that it's manipulative, it's designed for political ends, it's done for this or that person to win an ANC or DA conference? We submit to you, no. And that trial for us, as we will read, we keep calling it a dry run. We are saying that decision, we all say it's wrong, there's no dispute. We say, having seen what was discussed with different people, that decision too was malafide. because Mr. Zuma would have challenged decision. And maybe, whatever we think of him, whatever we think of Mr. Sheikh, maybe our conclusions about the evidence that even our SCA judges have commented about would have changed. We wouldn't have seen it that way. We know now that judges said Squires said there was a generally corrupt relationship when he didn't. That kind of mistake, even if it's made by the Supreme Court of Appeal, I want to say respectfully, happens when we have decided that the power we have, we're going to use it anyhow because we are using it against someone we've dehumanized, a scum. He doesn't need protection of the Constitution. And I'm saying all of those dangers are there. And I am not accusing the NPA lightly. I'm saying they are an important organ of state that we would like them to act constitutionally when our sons are accused tonight. I'm not saying they should be.
Sons, so it's
Girls, sons.
No, excludes daughters, so it's sons.
Well, yeah, I think there's research saying that most people who are in prison are male. Anyway, but with that said, I'm making a serious point because we miss it. We miss it because we want to lynch Mr. Zuma. It's easy to miss it. It's very, very easy to miss it. Because it's the part I said at the beginning that drives us. It's our psychological and intellectual blindness. Then I move. After his resignation, then we know that Mr. Pikoli became the NTPP. When Mr. Masogo tells you later about this point I'm making, and I'm mentioning at the point of Mr. Pikoli because we're going to see, I'm going to quote my own learned friend, Mr. Trengov, in that matter, because he was right. You read Mr. Trengov's heads of arguments in defense of a man, a prosecutor who refused political interference because it was wrong. You will see that our standards of dealing with different people are different. So Mr. Pikoli takes over. And I'm going to say Mr. Pikoli does one right thing, but it's wrong. It's right because he says, well, Polokwane is now gone. And Sheikh is now convicted. By the way, there's even things that Mr. Zuma did not suffer any prejudice. We say he did during that period. Social stigma is prejudice. But we may have forgotten that he did actually lose his job. It doesn't look like a job because he's deputy president because we think they are not human beings. He lost his job. Now, before I move to what Pikoli does, this is the part I said I want the court to bear with me. It's the longest I'm going to do. Is what does Nuga do during this period when he's there? Maybe let me move to Pikoli first because I think let's not spoil his story. Pikoli charges Mr. Zuma. And I'm saying it's correct because we're not here to say they should never charge Mr. Zuma. I'm saying it's correct because at the time as a lawyer, as he says, now I can charge. Criticize him for whatever you want to criticize him, but he takes a lawyer decision. I'm charging, and he doesn't waste time. So, why do we have a problem with the man doing the right thing, charging when he must charge? And why should you count that as delay caused by them? Now, this is since the 23rd. We say, as we move towards the 31st of July, before Judge Msimang in this division, we know now that this, what I call a correct decision to charge Mr. Zuma after the Sheikh trial. I don't want to dwell on the discussions or no discussions or trips with Mr. Mbeki to Shili because they are disputed. We know that when the state said we are charging Mr. Zuma, they were not ready. That is the second period I will invite the court. Why are they not ready? Why do we say they're not ready? We say so because we know that much later when the trial had to sit, and I'm going to go to that because Judge Msimang deals with this conduct. When you charge an accused, when you're not ready, and you don't need just a couple of days. We are told, oh, it's the nature of these matters, they take time. When you charge someone and leave him, hang him out to dry, to accumulate all the stigma that goes being called corrupt or a rapist, whatever we call people we don't like that have been accused, and you're not ready, you prolong for him or for her the social stigma that comes with being an accused person. And this is not, Mr. Piccoli says this himself, he does not contest that. And they don't contest that they sought a postponement before Judge Msimang. We are just making this point. Once again, a delay caused by the state. Charging someone, yes, legally it may be correct, they had to do it, but do it when you're ready.
But wasn't that also going to prolong? At some point, they knew that they want to charge him. If they had not charged him at that time, would that not have prolonged it? Because, and this goes together with the Ngcuka, forget about the motive at this stage. Ngcuka did not charge him because he says there was not sufficient evidence or whatever he did not have, so he did not charge. So on the face of Squire's judgment, if he had not charged him, would that not have added to the social prejudice?
I see the point. I
Yeah.
mean, if I'm not characterizing it correctly, you will tell me. You're saying, how can I argue that his prejudice was prolonged, but when he was charged early, there was something wrong? It's for that reason I used the phrase when I started. It was right and it was wrong. It was right because, yes, when I'm charged, you don't prejudice me when you charge me and you're ready to ventilate my matters in court. So it's right. That decision, the decision to charge, is right for that purpose. But I'm saying it's wrong because you know you're not ready. You're going to seek a postponement. So, if you don't charge the person, if I understand your ladyship says, well, if they didn't charge at that time, it should have prolonged that suffering.
So, in other words, are you suggesting that they were supposed to charge only after finalizing investigation? Is
when
that what
they're ready.
Yes.
That's what we say.
Being
It was
ready is
premature.
yes.
We say the fact that we complain that he had suffered is not a legal basis to charge prematurely. That's the submission.
But there were intervening events here, like the search warrants in August 2005.
No, not at the time. When he charged because they were ready. You charge because you're ready.
Yes, he was charged, but thereafter.
Yes.
Thereafter, there were warrants and all of that,
Intervening events.
which the state says interrupted their preparation
Absolutely. My
for
point
the
is-
trial. So that's why they were not ready by
Yes.
July 2006.
I'm posing this question to myself, but to the court. is this. Because I think the points I'm making get confused with their substance and whether we're saying they are responsible for the delay. I'm saying to the court, Mr. Zuma was not responsible for that decision. He can't be. The cases that are quoted suggest that Mr. Zuma cannot come to this court to claim delays because he is responsible for them. He is responsible for the delays, and I'm saying to the court, that decision to charge him prematurely itself, because those warrants were challenged, and I don't want to get into what happened to them, but that decision was a decision that charged him prematurely. And we say that delay falls squarely on the shoulders of the NPA, not Mr. Zuma. And so
are we talking about the period between the 20th of June of 2005 to the 31st of July 2006?
Yes. We're saying that period, that delay cannot be attributed to Mr. Zuma. That's the point we're making. We can debate later whether it caused prejudice, because we know that the cases say just delay on its own is not. There must be prejudice. We must demonstrate. On the 29th of June, we know that Mr. Zuma appeared in the Durban Merge Court. Right? The trial is adjourned to the 11th of October, 2005. And who asks for that? It's at the instance of the state. We say that in page 23 of our heads. Because it was not ready to proceed. Yes, it wanted to continue investigating him. On 26 July 2005, we know that the NPA instructed KPMG to conduct forensic investigation into Mr. Zuma. And can I pause here to say, when I said we compartmentalize this case, is that we are in 2005 now, since advised that he could have been charged. That's where we are. So when we justify that, oh no, they were still investigating, I want to place it to this court that we're dealing with an institution which at a particular point 2 years previously had been told that it could charge. Well, they instructed KPMG to conduct this forensic investigation. It was extended on 8 August 2005 to include allegations of fraud and failure of Mr. Zuma to declare his income in terms of Income Tax Act. I must pause here to indicate, my lord and ladies, that we've asked for several documents about these decisions. We've got some, but we've not got others. From people who 20 years ago, 15 years ago, were ready. We're ready to prosecute. On 11th of August 2005, the DSO, as we know, applied for and obtained about 21 warrants to search and seize documents from Mr. Zuma's homes and his attorneys. This is an important point because those documents were told remain in a trunk somewhere kept safe. I don't have them. I don't know them. He doesn't have them. They are there. These were, as we said, I don't want to get into, because it makes no point, how those the Scorpions raided those homes, but they did. But what we say in paragraph 3.6 is that Pikoli's decision demonstrates to us, and we submit to this court too, that the state was in a position to start Mr. Zuma's case without unreasonable delay, even before they conducted the investigations for which we excuse them. They were ready. They could have. Now, I'm going to move to a case because it's a case that is quoted. And I'm quoting these cases, and they are on point because it's when the courts refused to give a permanent stay. And the one that we quote there is Sanderson at page 24 of our heads. Well, what that case highlighted, it's a 1998 case, as we said. It said the following, and I'm saying it because a lot of things in that case may be against granting a permanent stay, in fact are. It says judges must bring their own experiences to bear in determining whether a delay seems over lengthy. This is not simply a matter of contrasting intrinsically simple and complex cases. Certainly, a case requiring the testimony of witnesses or experts or requiring the detailed analysis of documents is likely to take longer than one which does not. But the prosecution should also be aware of these inherent delays and factor them into the decision of when to charge a suspect. Now, I'm saying this because even before I deal with other cases, is that, yes, this case which is against us tells you that the door is not closed. The NPA must factor this in a decision whenever it takes it. And it continues, it says, if a person has been charged very early in a complex case that has been inadequately prepared, and there is no compelling reason for this, a court should not allow the complexity of the case to justify an over-lengthy delay. Furthermore, even cases which appear simple may involve factors which justify delay. The personal circumstances and nature of the witnesses, for example, should be considered. And they seem particularly important in this case. This is the case they were dealing with. There should also be some proportionality between the kind of sentences available for a crime and the prejudice being suffered by the accused. Pre-trial incarceration of 5 months for a crime, the maximum sentence for which is 6 months, clearly points in the direction of unreasonableness. The point we're making in this case is that it's not a mechanical comparison of which period is longer. It's a combination of things. But what are the exceptional circumstances in this case? Well, in the cases, for instance, where a permanent stay has been granted, none of them have the delay of this matter, of even more than 5 years. The cases where courts have said to the NPA, this delay is long. In the Phillips case, it was 3 years. We are here 15 years later. We submit to this court that if you look at that and the periods that I have raised as examples up to now, that delay falls squarely on the decisions of this organ of state that is the one that takes decisions when to charge and when not to charge.
Mr. Sikakane, if one if we consider the decisions of Sanderson and Van Heerden and a whole lot of other than that, also on a comparative level as to what the European Court of Human Rights had said, is it not true that when the court has to consider the application for stay, it's not focused on the number of years per se, but the reasons for the delay. And hence also that's why our Constitution allows for the unreasonable delay. The court will have to focus on the reasons, not the periods per se, but the reasons, because even in Sanderson's matter, it boiled down in the end, despite all of those various delays, it was labeled as systemic. So would you concede that it's not so much the number of years, but the reasons for the delay that this court ought to focus on?
The question you're asking me is difficult because I agree and disagree with you. I agree with the point you make to me that there are factors to consider, and of course the reason. It would be wrong to submit that the reasons don't matter, but I think it is equally. The case itself tells you about over lengthy delays.
Yes, but having said that,
yes,
you still have to consider the factors which caused that delay. That's a bottom line.
No, I agree, but I'm saying you're not going to the two. I'm not saying the two. They are not mutually exclusive.
Yes.
I'm saying you are not going to consider the other without looking at the other one. I am saying the reasons are very important. For instance, if I read these 4,000 pages and I found that throughout these 15 years, as our opponents say, Mr. Zuma was adopting the Stalingrad approach. I don't even know what that means. But he was week after week refusing to be tried. And it has happened in one of these cases here. And it's the case they choose to quote for us, the McCarthy case, which is an extradition matter. And of course the court had to refuse when a person who himself is hiding his assets turns back and says, I'm being delayed. So you, my lady, you are right. I agree. But I disagree with you slightly if your question to me is that the fact that a delay is over lengthy can be disregarded. But
no, that's one of the factors. That is one of the factors that has to be taken into account. But that's not the yardstick. What we use in measuring it must be, if I understood the Constitutional Court correctly, the reasons for causing that delay.
Yes.
So the period, of course, must be one of the factors. So I think we are agreed on that score. The period is not totally irrelevant, not at all. It is but a factor to be considered.
You see,
in fact,
I was going to say to you that we have to look at the factors which have caused us to find ourselves in the position that we are now.
Yes.
For us to be able to determine whether the application is granted or not. That's the underlying. Those are underlying factors that we have to consider.
I accept
Yes.
that, and what separates us
Yes.
in this room, this side and this side, is that they say we're responsible for that time.
Yes, it's for us to determine.
And we suggest to you that it's not true. The facts reveal who was deciding prematurely to do what. Mr. Zuma does not set dates for trials.
So you are arguing a case on the basis that it was the state's fault that we find ourselves in this
I'm
position.
saying we find ourselves in this state because of the state and how it handled this matter. And, my lady, while we're there, you say to me that the issue of time, actually in Sanderson's case, the lapse of time is said to be central.
Yes.
They say it's central. So it's not really correct to elevate, not to elevate it, to elevate the others.
No, I think maybe you're misunderstanding
Okay.
her. She says it's one part
Then-
of the other phase. It's not in
I
isolation.
agree. I
Yes.
don't disagree. I'm just
Yes.
saying it's central as well. The lapse of time is central, and it should be looked at with other factors like what reasons caused it. My lady, I'm sorry if I misunderstood.
Yes,
You
I
misunderstood.
think
It is
that's why we-
it is a factor. It
Yeah.
is not the factor.
No, it's not the factor. If I was told that in the documents Mr. Zuma caused all of these delays, I would have told him that I can't do this case. But he didn't. The state did. Well, now of course, let me just, while we're there on the Sanderson case, because how our learned friends start their heads of argument is about the seriousness of the crime. The Sanderson case also was about a very, very serious matter of a singer who had sort of abused young girls. So the seriousness of the issue is always an issue when you're taking a legal decision as to when you do what. We don't dispute that. And when our learned friends start with a lecture to us about corruption, it's not that we don't understand corruption or we like it, or we think it's not, we're not of a species that doesn't understand that. What we are saying is there is absolutely no reason to act unconstitutionally, and your basis is that I am pursuing something that is serious, not for a prosecutor. He or she has enough powers within the law to pursue an accused without having to go outside constitutional conduct.
But it is one of the factors that we have to look at, the nature of the offense in question. That's another factor.
I'm going to say yes, but I don't want to say yes and leave it there because it's a mistake that we make all the time. It's where I started. The nature of the offense is important. And I submit that you must balance that, as your ladyship was saying, with many other factors. But what I will not concede, and I hope no one does believe that, is that there is, in a constitutional, in a modern state, a caring state, something that would warrant acting unlawfully and unconstitutionally because we don't like what people have done. It's for that reason that we all in this room live with people who did horrible things to our parents for years. Because we live in a state that says we can never pursue them in the streets because they oppressed us. We must do it within the Constitution. Therefore, the point I'm making is there can never be a reason that because we suspect you've done something. In fact, that standard, I would add, we don't even use towards people. We don't suspect killed children in 1976. We know they did. We don't use it. And so I am suggesting that it would be unconstitutional. While you consider it, I'm inviting the court to take that point into account. And the DSO itself at some point accepted that the matter could not continue without end. And there were exchanges of letters between Mr. Zuma's lawyers at the time and the DSO. And all of those things, they indicated that Mr. Zuma was calling not to be treated differently or that he should not be prosecuted. Until today, we bring this 15 years later, but he has asked, please do it right. Give me my day in court. I want to say what I want to say, but that opportunity was always missed. I'm going to pass through those pages where we deal with the exchange of letters and the warrants, because very little turns on it for me to persuade you whether or not you should grant the relief. But they are what they are. I'm doing this in the interest of time. But I want to go to page 29 and say that, as we say there, until last year, the indictment of this case was not final. I think I say this because on the 27th, if I'm not mistaken, on the date when we're here is last year, the indictment was not final. Eventually, a letter was written not to us, to Thales.
You say from what time? From when?
I'm saying when we appeared here last year in
No,
2018.
you're saying up until when you appeared here. From which time you say it was never? Are you saying
It has never been. It was not final.
But was it the one that Mr. Mshe had? Was that not?
Well, that's a different one. Yeah, I'm saying after that, until last year.
Because I think maybe I misunderstood. I thought you said it has never been until.
No. Not that it has never. I'm doing different periods. I'm saying that one. That last year we were told it's not final. Eventually it was. I'm told it is now. I hope. On 12 May 2006, further litigation ensued between the NPA and Thales. It is all related to their further particulars. I don't want to bore the court with that. The NPA alleges that on 23 May 2006, it instructed KPMG to finalize the forensic report. My instruction is that we don't have that report to date. I'm told it's fine.
Yes, can you clarify the receipt
I'm told I'm
instructions?
wrong.
Yes.
That point.
Yes, I think
I'm
it's because
told
there
I'm
is.
wrong.
Yeah.
I'm told I'm wrong. I was overzealous about the point, but I'll take instructions.
I see when you're
because
passionate about something.
it's my instructions. Well, I suppose this case you have to do it to know what it means to those who are accused. Well, we say that, because I'm dealing with how this matter got delayed. On 26 June 2006, the DSO wrote to Mr. Zuma, and that letter I don't need to read, the court knows it, and wrote to Mr. Zuma in tint and stated that the state was of the view that it would not be possible to commence the prosecution in this matter on 31 July 2006. Now, this is the state that charged, that said we're ready. Anyway, they indicated that realistically the trial would have to commence sometime in February 2007. And they set out a number of reasons. Said the state was being hindered in producing the final report. The forensic report would be provided by 31 July 2006. The state intended to pursue their litigation in respect of letters of request and said it was undesirable that the matter commences before the finalization of the Sheikh appeal in the SCA, which was then to be heard from 21 to 25 August 2006. We were told, or they were told then, that the state would be focusing on this. We submit that delay too is attributable to the state. The second question is, can the state tell an accused, sorry, we're going to delay dealing with you because we're busy with something, another case? We submit that reason is not legitimate as a reason. They could have pursued the case. They have sufficient and a number of prosecutors that could prosecute people at different times. It's happening as we sit. And that's why we say in our heads of arguments, those reasons were unconvincing. That too is not Mr. Zuma's delay. Well, Mr. Zuma, correctly in our view, and his lawyers refused to agree to that postponement and indicated that he would oppose it. He threatened then that he would seek a permanent stay of prosecutions, the one we have. Now, this was a matter to go before Judge Msimang. On 12 July 2006, Zuma requested further particulars to the provisional indictment, and it had not provided him with those. On 19 July, the state formally made an application for postponement. It's the state that charged him when it should have done so when it was ready. It wants a postponement. This application was heard by Judge Msimang. And of course, it stated therein, I don't have to get into the details, why it sought this and why it sought these delays. But what's important is, what did this court, this division say? What did Judge Msimang say about this conduct? And I would like to read to you a couple of paragraphs from this judgment, because we deal with it later, because it tells us that the courts themselves, even at the time, had said that the conduct of the NPA was unacceptable as early as when they sought the postponement more than 10 years ago, in 2006, on the 31st. And it's scathing about the conduct of the NPA towards the accused, towards Mr. Zuma. I will get to a series of those criticisms by the court. But there's a mistake that I think runs through the papers, about which I think are not for everything, but inspire the accusation that Mr. Zuma was responsible for the delays. And you see it when you read the papers that, for instance, much later, when Mr. Zuma was eventually charged, and I will deal with the month between November and the 27th of December in the spy tapes, there is an assumption, and it's rather wrong, that when the NPA, through its leaders, let's say like Mshe, or when they decided to appeal a particular decision, somehow what you find in the papers is that a decision of the NPA, which seems to favor Mr. Zuma, right? Let's say Mr. Mshe's decision. It's a delay by that institution we submit. It is irrelevant that it may have been a decision that seems to favor Mr. Zuma. We do not have to separate the institution from its decision that added to the delay. Now we have, let me jump to the time now, because it's more important in this case. This is the time when now Mr. Mshe is the NDPP. And this is the decision to decide, and it's important that what I'm going to read to you is the discussion, verbatim, of, because we talk about these spy tapes and we don't know exactly what people were saying and why they were saying it. And it's all built, our learned friends say it's a conspiracy that we've constructed. We've not constructed any conspiracy. We're referring to discussions between an institution that should act without fear or favor, discussing with politicians when to charge a person they want to charge and why. Can I take this quote? Because this is just before the other period we're going to suggest is attributable to the to the NPA. Page 1519. That is volume 6. But,
You said page?
1519. Or if you just have that bundle, because I'm going to make, I can't read all of it, but I've marked the parts that I think make the point I've been trying to make about political interference. And I'm making this point because the cases tell us, as we've had a debate in this court about what other factors must we consider. This is done only in extraordinary circumstances. I'm going to read this because I want to submit that a number of these discussions are extraordinary about this case, are extraordinary about how to pursue a human being simply because you think they are guilty or you think they are going to be elected president of a party.
Perhaps just before we get to it, Mr. Sakana, because this issue was raised in the SCA judgment about the authenticity of these reports and a judge's certificate that ought to have been obtained. That previous court had not had them. The SCA did not have it. And us, are we entitled to ask, or should we just accept what?
My lady, I would say you are entitled to them. They actually, the NPA itself has spoken about them. The decision by Mshe, he had obtained them now because he knew they existed. And when he makes that decision, that the actions of his own institution to allow political interference were diabolical, they are here now. He was referring to them. It's a document that made him make the decision not to proceed with the charging. There is nothing that stops this court.
But the SCA labeled them as just hearsay.
Yes.
Yes.
They do.
Yeah.
They do.
What weight can we then attach to them?
Well, my lord, I'm answering a different question. I'm answering a question whether they are before you. I say they are. My lord, they have not been disputed. Then.
But I think the issue that I have is that the SCA has found that they are hearsay in their judgment. They say they are hearsay.
When?
And if it has pronounced on that they are hearsay, without the certificate or...
Here is what should keep you calm about this and put you at ease.
Yes.
These conversations are about Mr. Nguga here, who admits them. I can take you to Mr. Nguga's affidavit if you would prefer.
But does that make them admissible?
Absolutely. The person about whom, I am not going to read those parts if we don't want to hear them where he's not involved. Mr. Nguga specifically, in this case, agrees that this is what he said. There is no reason whatsoever. Apart from this, the NPA itself, because the NPA can't, as it chooses, distance itself from some of its leaders, that Hofmeyr himself in that DA application writes about how this conduct offended him, refers to them. So I'm saying, for purposes of what you have to determine, Mr. Nguga, who is central here, confirms them. And I would like to read parts of it to you that I think are a pattern of what I think should inform some of the factors I submit you must consider when you're answering the question, is there anything, is there a violation, is there anything extraordinary? This is the discussion between Leonard McCarthy. The date is the 9th of November 2007. It's a couple of weeks before the conference of the ANC. Patty, I'm going to take you to where they get to what we're dealing with. And I'm going to go right there at the beginning because I want to demonstrate from line 4 the disdain with which they discuss Mr. Zuma. Mr. McCarthy said, Mr. Nguga says, all right, let me start at the beginning with 3. This is Bulelani. How is it, bro? Do you remember a CV I gave you for the guy from the Presidential Protection Unit? Part of it doesn't seem relevant, but I want you to bear with me. The client have to go on normal process, headhunt and interview. They already had good candidates. So they recommended these candidates, but 2 of them, one guy for Vusi, well, Vusi when he was still Vusi. Then Bulelani says, I would recommend this guy for you in particular. And Leonard McCarthy says, is it? Says, yeah, he can sing Mshiniwami nicely. They laugh. It's a laughing matter to them. And then Bulelani says, no, seriously, I seriously recommend him. So that part, I'm introducing it because that's the casual nature of the discussion about very serious matters. Well, let's go down to a discussion they have from line 26. Leonard McCarthy says, I just wanted to say between you and me, that was the last time that I, Leonard McCarthy, attempted to predict the outcome of a judgment. And I'm raising this point because, as I said to you, these are people who are a law unto themselves. You know that can't. Now, any one of us could think the person called this name would not be human. Well, they are talking about our judges in the Supreme Court of Appeal. You know that Kant, Ian Fallon, the retired judge, and Tom Clute, they were fighting with Kemp and Zuma's counsel during the hearing. So much so that we all thought they were on our side. They were actually ridiculing them. Yes, says Bulelani. Okay. Leonard McCarthy says, at some point, Fallon apparently said to this guy, stop. Or is it Tom Clute said to Kemp, stop, stop. Tell me what is wrong. Yes, says Bulelani. What is it that they have taken that does not fall within the confines of the warrant? Yes, Leonard McCarthy said, so you read the judge's body language. Yes, says Msengu. And then they come and fucking spin around just like this to drop you. They're talking about judges. Bulelani says, no, they dropped us. And Leonard says, no, no, no. I'm saying we won in the end, but it was damn close thing. It was 3-2. Are you serious? 3 judges for us. And the guys who are regarded as betting for us, that's Fallon, Judge Fallon, and Tom Clute, turned at the last minute and gave us a dissenting judgment. Both of them, Jesus, says Leonard McCarthy. Bulelani Nguga says, and the one you said you thought he was not with you, who was it? Leonard says, no, they say there was this one guy, or this one judge, Ponen, the Indian guy. He asked nothing. Yes. And then Leonard says, Dunstan Mlambo asked one or two questions. Both Falam Klute went for the other side. Robert Nugent initially asked some very tough questions. Yeah. In the end, Nugent, Ponen, and Mlambo came home for us. Why am I reading this? Because we haven't come to the conspiracy. I'm reading this part simply to tell you the type of people we were talking about and their conduct and how they saw themselves in executing their powers. Well, I'm going to pass, and can I take you to the next page? Few paragraphs I want to read. That is page 1522. This starts to get important because it's going to show what I thought is a pattern of behavior. The plan about Pulukwane is starting. An organ of state starting to count who will vote for who. I don't know why that was their business. Can I start with line 30? Bulelani Nguga. Oh no, 28. Then Bulelani Nguga say, it's Mpumalanga and Free State and Natal, man. That's giving us a real problem. It shocked the system. And Leonard McCarthy, who was part of the NPA, says, yeah, it is. We knew we were going to lose, but we did not think that. And it's not natural, Leonard. When you have your president being rejected by such a huge majority in a province like that, you would find, if you find, for example, that if you look at all the provinces, you can see that people have a difference of opinion, different views. And in line 33, they continue this banter. They say, Leonard says, there's something wrong here. And also, this is my first reaction. There's something wrong. My reaction was twofold. It is either that the one side deliberately is obfuscating the issue by saying, no, go and vote in droves. No, go and vote in droves against this guy. And on the side you will see, and I don't want to put much in this, they speculate Mbeki. But I don't want the court to, it has a question mark, so I don't want to go there. To vote in droves against this guy. The real picture will emerge at the conference, and these guys cooked the books. And I agree with you, absolutely. Something very, very ugly. Well, my lord, the red may not be important. At 1523, the plot thickens. Because you start to see who they want to use this organ of state for. Leonard McCarthy says in line 51, I thought they were pro-president. That's what it read. They were last week laughs. Last week they were. So he laughs. Today they've changed. Now, this is the part I want because it's the precursor to everything that happens. What Bulelani Nguga, who's no longer in the NPA, he simply interferes here because he's the husband to the deputy president. He says, because they've seen the winds, and Leonard McCarthy says, then Bulelani, here's the punch. So you are the only one who can just save this country from the madness. And then Bulelani says, I just can't believe this thing. I really can't believe it, man. I don't know. So we are all busy now doing some soul searching, says Leonard. And And then, and what does the big man say? Is he all right? We saw at the end who is the big man. They put in inverted commas. Is the big man they seem to support, they both, and there's nothing wrong with that.
So can we come back at 2:15? I see it's almost
Yes.
2:15. Should we come back at 2 or 2:15? Is that it's up to you?
2:45. The earlier the better.
2 o'clock is fine with everybody. Oh, we're coming back at 2 o'clock.
engathi nzima kakhulu le.